picture it. You have your estate plan drawn up and in place, and you're satisfied with your choice of beneficiaries, your successor trustee, and what assets you're going to hold in your trust to begin with. However, your trust specifies that beneficiaries need to be at least age 18 before they can receive their inheritance, a common requirement since you don't want your young grandchildren, for example, to be irresponsible with their inheritance. However, as time has gone on, that provision gives you a bit of pause. You don't want to leave your grandchildren out entirely, but you aren't sure they will really be responsible with their inheritance, even if they are 18 at the time they receive it. After all, with the way things are now, they will probably still be living with mom and dad at 18, so it's not like they have any pressing bills like rent or regular groceries to worry about. Plus, if the money stays in trust longer, that just means it has a longer time horizon to grow from being invested before it ultimately goes out. So you decide, instead of 18, you want your trust to hold the funds until age 30, but leave everything else alone. So you grab a pen, scratch out 18, write 30, and you initial the changes before putting your trust away and never thinking about it again. Everything's fine, right? Hi, I'm attorney Andrew Bethel. The surefire way to invite a challenge as to the validity of your estate planning documents is to make changes, adjustments, or even amendments to those documents by handwriting your wishes on the document itself. The judge will hate it, your successor trustee will hate it, your beneficiaries will hate it. The only one who will like it is the attorney representing the party that is now challenging that change. Now, in a theoretical sense, as in on a law school exam, this type of handwritten change can be argued as a valid amendment to the will or trust, but again, that's going to be theoretical and in a controlled environment. One where all the facts are known, including the settlor's intent, the one who set up the trust and made that change. But the real world, it's not a law school exam essay. It's messy and filled with incomplete pictures of events, since us will never really know every relevant fact or somebody's subjective intent. In the real world, a situation like the one I just outlined is one where that beneficiary who is age 20 at the time you're passing will go to an attorney and could very easily mount a compelling challenge as to the validity of that change. Consider the likely path here. If your successor trustee insists on honoring that handwritten change, as they arguably have a legal duty to do, the matter is going to come before a judge, who will be the arbiter of the outcome, and as mentioned, the judge will not likely take kindly to this type of legal battle. It's a matter that takes up time on the judge's calendar and the court, yet comes down to trying to divine your subjective intent after you pass away. With crossouts and scribbles, the judge won't know who made the mark, when it was made if you didn't write the date, or whether you really intended to make that change in the first place. The judge, they're going to see a beneficiary requesting their inheritance as formally written in the document, a successor trustee who may stand to gain by collecting their entitled yearly trustee fee until the beneficiary becomes of age, and they're going to be arguing the informal change should be honored. And the lingering question that if you really intended that change, well, why didn't you go to a lawyer and formally update your will or trust like you did initially? For all the judge knows, absent more evidence, the successor trustee could have made the change to keep the funds under management, that much longer. Thus, the judge could, understandably, find the change was not valid and order that the funds be distributed as formally written. Therefore, to be safe, always speak to your attorney when you want to make changes to any provisions in your will or trust. Going through the formal procedure for updating your documents, that evidences your intent and provides witnesses your intent and state of mind. in that the attorney and their staff witnessing, they're going to be your witnesses for your wishes. Finally, a great attorney will keep records of changes in their file, and you should keep amended documents with your existing documents, so it is clear to your family you intentionally made changes to your documents over time. Thank you for watching. If you enjoyed the video, be sure to check out some of our other excellent videos here, but don't forget, hit the like button, subscribe, ring the bell, and tell us what you'd like for us to cover down in the comments below.